Hello, it's Philip Taylor from Richmond Green Chambers speaking. I'm looking at the Brown Book. It's this one here. It's the Civil Court Service 2010 from Jordan's. It's similar to the other publications that you will see, the White Book and the Green Book, or Blackstone's Civil Practice. My wife and I have written a review of this on Flickr. You'll find the websites have copies of the written review, and we've given it the title Fast, Reliable Answers When You're in Court to a Wide Range of Civil Litigation Problems. This book's one volume. It's 3,000 pages long. The paper's a bit thin, which is bound to be the case, but it has a massive number of erudite contributors, assisted of course obviously by Lord Savile and Lord Justice Laws, but certainly the general editor, Neil Hickman, has done a superb job. This is what we say in general about this work, and I'm not expressing any preference here because I've used all of these publications. We remember writing a review, and I actually did it, of the first of these books for the Barrister magazine in 1999. That was the year when the end of the century heralded the new beginnings of the law in the form of the new CPR. And Lord Justice Laws lauded the Brown Book then as the vade mecum to the then new regime assembled by experts and convenient and easy to use. That's what it is. Depends very much on what you particularly get used to. I was used to the Green Book and the White Book because of my bar vocational course studies, but this particular work I do find very useful depending on which court I'm in. Milton Keynes is one where I would take this because District Judge Hickman is there. So 10 years on, what is this about? The new edition maintains the virtues of the original in our view, whilst encompassing a wealth of new material which reflects the momentous changes that have taken to the CPR. We're looking at the 51st update of CPR, and obviously we therefore think that this is one of the really authoritative works on offer. It would be impractical as well as impossible to list all the new material in the new edition, but obviously there are important things stemming from the Legal Services Act 2007 in particular, and various other matters involving the permit service of documents on a party's legal representative, say in the European Economic Area. So there are changes which it's identified very, very well. Of course, the moral to this story is do make sure the opposing solicitor in question is served at his or her business address if it's in the EEA, or the purported service would be invalid. So that's an example of something relatively new for this particular edition. Another example of a Euro-linked amendment follows the coming into force earlier this year, 2010, of the new 2007 version of the Lugano Convention on Jurisdiction and the Recognition and Enforcement of Judgments in Civil and Commercial Matters. Always a difficult area, and one that I think is confusing both to students, trainees and even practitioners. On a more mundane sounding but pivotally important issue pertaining to your everyday practice, we fully applaud Hickman's remarks on another new development regarding timings for filing and service of statement of costs, not less than 2 days before a fast-track trial and not less than 24 hours before any other hearing, which does not mean at 4 p.m. before a 10:30 hearing the next day. These things are important, and if you're in front of Hickman or any of these judges, it really is very important to know what you're doing. Those of you who have habitually filed documents on the dot at 4 p.m. the day before a telephone hearing, expecting them to reach the court file and intending a wax indignant when they don't, had better get out of the habit, it is said, and rightly too, because these days all this information is tracked. Do remember that, because this is part of the modern age, because it's got the CD at the back. In addition to District Judge Hickman, the erudite contributors number no less than 10 judges, 4 solicitors, 4 barristers and a silk, with over 60 procedural guides to make key applications to the court, together with expert commentary on the rules and relevant statutes. The Brown Book has been called the natural choice for the general civil litigator, especially in the county court. I'm loath to give any great strength to any of them, but I do find this helpful because it has a way of expressing stuff very clearly. The law's stated at January 2010, and if you want to be truly up to the minute, it's recommended that you check online for details of the latest procedural changes. Thank you, Neil Hickman, and your excellent team. It's a great contribution to CPR. All the very best. Bye-bye.